Section 7 of your Rule 112 is about records. And we start with letter A, that is records supporting the information or complaint. But before we proceed or before we read letter A, let us first take a look at let us first recap the process or the procedure of your preliminary investigation. So if the penalty of a case is at least 4 years, 2 months, and 1 day, then the law requires that a preliminary investigation must be conducted. So meaning to say, the case or all cases filed in the RTC must undergo preliminary investigation. They must go through preliminary investigation. How about in MTC? In MTC, depende. If the penalty is at least 4 years, 2 months, and 1 day, then it needs PI. Pag below 4, 2, and 1, then it does not need PI. Bakit lahat ng RTC cases kailangan magkaroon ng PI? Because for you to file a case in the RTC, what is the jurisdiction of the RTC? It is 6 years and 1 day. So what is the procedure? The procedure starts with the filing of the complaint. Who files the complaint? That is the offended party, your complainant. And what is the next step? There will be an action on the part of the investigating officer. Sa totoong buhay, when you file your complaint, then it will be raffled, it will be assigned to an investigating prosecutor, to a specific investigating prosecutor. And then the investigating officer will read the complaint together with the evidence, together with the attachment, the annexes like the affidavits, and then he will act on the complaint. What is his action? It's either he will dismiss the complaint or he will issue a subpoena. He will issue a subpoena to the respondent. And what will happen next? The respondent will now file his counter affidavit. And kung gusto ni investigating officer or ni investigating prosecutor, if there are matters that needs to be clarified, then clarificatory hearing may be conducted, but take note that this is only optional. After this, there would now be a resolution of the investigating officer. Take note ha, yung resolution of the investigating officer, it does not matter if the respondent will file his counter affidavit or he will not file his counter affidavit. It will not prevent the investigating prosecutor to render a decision or a resolution on the complaint. So the resolution will either be dismissed or he will hold the respondent for trial, and in that case, he will prepare information. But of course, take note of your Section 4. Ano ba ang sinasabi ng Section 4? The resolution of the investigating prosecutor or the officer is not yet the final decision because it will be reviewed by his or her big boss, and the decision of the big boss is the final decision. Yun yung iaakyat sa court, yun yung ia-appeal mo kung gusto mong mag-appeal sa Secretary of Justice. So take note of that. So, ang sinasabi ng Section 7 sa atin sa Rule 112, that if ever the decision of the investigating officer is to hold the respondent for trial, then information should be filed. And according to Section 7, if you're going to file your information, where are you going to file? In court. You are going to file that in court. And what is the requirement of the law? When you file your information, it should be supported by the affidavits and counter affidavits of the parties and their witnesses, and you have to support it also with evidence as well as the resolution on the case. So that is the requirement of the law under Section 7, letter A. So take note that the preliminary investigation is conducted by the investigating prosecutor, and then his work is conducted by his big boss, either the city prosecutor or the provincial prosecutor. And who are their employers? Their employer is the Department of Justice. That is the Department of Justice. And under what branch of the government is the DOJ? They are under the executive branch of the government. They are under the executive branch of the government. And if you're going to study your political law or your constitution, the head of the executive branch of the government is the President of the Philippines. And what is their mandate? They implement laws. Kung yung legislative branch of the government, they make laws, the executive branch of the government is they implement laws. So, if the decision now of the investigating officer, or if the final decision rather of the big boss is to hold the respondent for trial and file therefore an information against the accused, where are you going to file your information? You are going to file that in the court, either in the MTC or in the RTC. And under what branch of the government is the court, or the under what branch of the government is the RTC or the MTC? Are they also in the executive branch of the government? Answer is no, because your court is under the judicial branch of the government. They are under the judicial department of the government. And sino ang namamahala ng judicial branch? That is your Supreme Court. So from executive department, take note, yung preliminary investigation conducted by the executive branch of the government, ililipat mo ngayon sa judicial branch of the government. So magkaibang branches ng government. That is the reason why if you're going to read your letter B of your section 7, the record of the preliminary investigation is not or do not form part of the record of the case. The record of the PI conducted by the prosecutor or the other officers, as they are authorized by law, they do not form part of the record of the case. But do you have a remedy if you want it to be a part of the record of the case? Answer is yes, because you can file a motion ordering the production of the record, or a motion ordering the production or of any of its part when it is necessary in the resolution of the case. What else can you do? You can introduce it as an evidence in the case. Take note that the court also can do this on its own initiative. So let us just say that the final decision is to hold the respondent for trial, hence an information will be filed against that person or against that accused. So where are you going to file your information? In the RTC or in the MTC. So we'll start with the RTC, yung information final sa RTC. So what will happen next? What will happen next according to Section 5 of your Rule 112, letter A is within 10 days from the filing of the complaint or information, the RTC judge will personally evaluate the resolution of the prosecutor and its supporting evidence. Take note ha, yung requirement ng batas is personal evaluation of the judge. Kaya yung information, pag final mo yan, hindi lamang yan yung one page of paper. Kailangan kasama lahat ng mga affidavits, kasama lahat ng mga ebidensya, so that it will guide the judge to make that personal evaluation. And when the judge now makes a personal evaluation, what could be his decision? It's either he will dismiss the case. What is the basis of his dismissal? If the evidence on record clearly fails to establish probable cause. What else can the judge do, RTC judge do? He can issue a warrant of arrest or a commitment order. When can he issue a warrant of arrest? If he finds probable cause. So kung sa tingin ni judge walang probable cause, result is dismiss. Kung sa tingin naman ni judge merong probable cause, then he can issue a warrant of arrest, and for those already arrested, a commitment order. What else can he do? He can also require the prosecutor to present additional evidence. In case of doubt on the existence of probable cause, the judge may order the prosecutor to present additional evidence within 5 days from notice, and the issue must be resolved by the court within 30 days from the filing of the complaint or information. And speaking of warrant of arrest, relate that to your 1987 Constitution, particularly the Article 3, the Bill of Rights. According to Section 2, warrant of arrest shall not be issued except upon probable cause determined personally by the judge. Kaya yung DOJ, yung mga prosecutor, they do not have that power to issue a warrant of arrest because no less than the Constitution states that only judges can issue a warrant of arrest. So let's change the situation. Instead of the information being filed in the regional trial court, let's say that this information is filed in the MTC. MTC does not only mean municipal trial court, ha? It also means metropolitan trial court if you are in cities, municipal trial court in cities, or the municipal circuit trial court, the MCTC. So what will happen if the information is filed in the MTC? According to Section 5, letter B of your Rule 112, the same procedure. The procedure for the issuance of a warrant of arrest by the judge shall be governed by paragraph A of this section. Ano nga ulit yung paragraph A? We discussed that already. The judge will, within 10 days from the filing of the complaint or information, the judge has to make a personal evaluation, personally evaluate the resolution of the prosecutor as well as the supporting evidence. And when he makes that personal evaluation, depende kung anong mangyayari. Kung walang probable cause, then dismiss. Kung merong probable cause, issue a warrant of arrest, or if in case of doubt on the existence of probable cause, then he can require the prosecutor to present additional evidence. So if I'm going to compare these options given to a judge, a municipal trial court judge, but PI was required because the penalty is at least 4 years, 2 months, and 1 day, vis-a-vis to a situation wherein PI is not required because the penalty is less than 4 years, 2 months, and 1 day, but filed in the MTC. Here, the MTC judge has more or less the same options, but titingnan nyo kung saan sila nagkakaiba, ha? Kasi nagkakaiba sila kung parehas nilang madismiss kung walang probable cause, or they can require the presentation of additional evidence if there is a doubt of probable cause. But if there is a probable cause, kung it requires preliminary investigation, if there is a probable cause, you can already issue a warrant of arrest and a commitment order. Take note that if the case does not require a PI, then the judge has 3 options. The judge has an option either to issue a warrant of arrest or a commitment order kung nakakulong na, or summons. If you're going to read your Section 8, Rule 112, cases not requiring a preliminary investigation or cases not covered by the rule on summary procedure, when the MTC judge finds probable cause, he has that option to issue a warrant of arrest or a commitment order, if the accused had already been arrested, or if the judge is satisfied that there is no necessity for placing the accused under custody, then he can issue summons
instead of a warrant of arrest. Take note ha, dito sila nagkakaiba. Kung ang case does not require a PI because the penalty is less than 4 years, 2 months, and 1 day, then the judge has the option to issue summons instead of a warrant of arrest. So in summary, if a case requires a preliminary investigation and later on it was filed in the RTC or in the MTC, as long as the penalty is at least 4 years, 2 months, and 1 day, then the judge has 3 options. Either dismiss if there is no probable cause, if there is a doubt on the existence of the probable cause, require the presentation of additional evidence, or issue a warrant of arrest or commitment order if there is a probable cause. If the case does not require a PI, meaning to say it will be filed in the MTC and it does not require a PI because the penalty is less than 4 years, 2 months, and 1 day, actually, they are the same. Saan lang sila nagkakaiba? Dito lang sila nagkakaiba because here, the judge has that option not to issue a warrant of arrest but instead issue only summons. Take note ha that itong pinag-uusapan natin, this is the rules on criminal procedure. So we are talking about the regular procedure and whether the case undergo or go through preliminary investigation or it will not go through preliminary investigation, either it is filed in the RTC or in the MTC. Take note that the judge has that option to issue a warrant of arrest if there is a probable cause. But if we're going to compare this to your rules on summary procedure, you watch my video yung sa summary procedure, just check the playlist. Ano ba ang nangyayari sa summary procedure? According to Section 13, should the court, upon a consideration of the complaint or information and the affidavit submitted by both parties, finds no cause or ground to hold the accused for trial, then what will happen? It will order the dismissal of the case. But if there is a cause, then what will happen next? It will set the case for arraignment and trial. So, unlike in the regular procedure wherein the judge can issue a warrant of arrest if there is a probable cause, take note that in the summary procedure, what will happen next is not the issuance of the warrant of arrest, but only scheduling of the arraignment and trial. Bakit? Because if you're going to read your section 16, in summary procedure, you are not going to arrest the accused. There is only one instance wherein you can order the arrest of the accused, and that is if there is a failure on the part of the accused to appear whenever required. Again, Section 16, the court shall not order the arrest of the accused in summary procedure except if there is a failure on his part to appear whenever required. So down to our last slide, this is the probable cause. What are the instances wherein you need to establish probable cause? We discussed two already. The first instance that we discussed is this one, the preliminary investigation. Again, who conducts your preliminary investigation? That is conducted by your prosecutor. And your prosecutor is under what branch of the government? They're under the executive branch of the government. Kaya ang tawag dito is the executive determination of probable cause. And for what reason, why they are determining probable cause? It is for ascertaining whether the respondent should be held for trial. The other instance wherein we discussed probable cause is this procedure. Here, either the MTC or the RTC judge will make a personal evaluation. he will make a personal evaluation, and if there is a probable cause, then the judge will issue a warrant of arrest. Ang tawag sa procedure na to is preliminary examination or preliminary inquiry. Again, this is conducted by your MTC judge or the RTC judge. And this is under what branch of the government? Executive ba ulit? Answer is no, because this is under the judicial branch of the government. Kaya ang tawag dito sa examination na to, this is the judicial determination of probable cause. But the reason here or the purpose here is for the issuance. You want to determine if there is a probable cause so that you can issue a warrant of arrest.